Picture this. Your team is using an AI tool to help filter job applications. It saves hours every week. It ranks CVs, flags relevant experience, helps your hiring manager build a shortlist. Brilliant bit of software. Now, here's the question. Do you have any documentation saying a human reviewed every decision it influenced? Do your applicants know AI was involved? Have you logged how the system was used and kept those logs for at least 6 months? Because under rules that took effect in 2026, if you're operating in EU or employing staff in certain US states, those aren't best practices. They are legal requirements. And this isn't about whether you built the AI. You just have to use it. I'm going to walk you through exactly what's changed, what it means for a business like yours, and a checklist of things you actually need to do about it. Prioritized, plain English, no law degree required. Let's start with the big picture, because the first thing that confuses people about AI regulation is how fragmented it looks. There's an EU law, there's American state laws, there's the UK doing its own thing. It feels messy, but once you understand the structure, it's actually quite manageable. Think of it in 3 layers. Layer 1, the EU AI Act, the most comprehensive AI regulation in the world. It entered into force in August 2024 and has been phasing in ever since. The headline date that you need to care about is August 2nd, 2026. That's when the bulk of the obligations kick in for most businesses. Now, a lot of people hear EU law and think, not my problem, we're not in Europe. But the EU AI Act has extraterritorial reach. If your business affects EU citizens, sells to them, employs them, processes their data, you may well be in scope. And if you're a UK business with European customers, it's the same conversation. The Act borrows the same logic as GDPR, and we all know how that one played out. The Act divides AI systems into risk tiers, 4 levels of concern. Unacceptable risk, things that are simply banned. Social scoring systems, real-time biometric surveillance in public spaces, AI that manipulates people subliminally. Most people aren't building this, so move on. High risk. Now, this is where it gets interesting for operators. Recruitment and HR tools that use AI, credit scoring, insurance pricing, worker performance monitoring, or educational assessment. If your businesses use AI in any of those contexts, you are operating a high-risk AI system under this law, and that comes with specific obligations. Limited risk. Chatbots, AI-generated content, emotion recognition tools. The main requirement here is transparency. Users must be told they are interacting with AI. Minimal risk. Spam filters, AI features in your analytics dashboard, recommendations engines, no specific obligations. Most routine business AI tools sit here. As of today, 2 things are already enforceable. The ban on unacceptable risk practices has been live since February 2025. And the AI literacy obligation, which requires businesses to ensure staff who use AI tools have sufficient understanding of what those tools do and what their limitations are, that's also live. August 2026 is when the full weight of the law arrives. Layer 2, US state laws. Now, there's no federal AI law in the United States, at least not yet. Instead, a growing patchwork of state legislation. And as of early 2026, several of them are already live. Now, the one that catches most people off guard is Illinois. Illinois HB 3773 came into force on January the 1st, 2026. There's no company size threshold. It applies to every employer with at least 1 employee in the state. And if you use AI in any employment decision, hiring, promotion, discipline, termination, you must notify employees and applicants that AI was involved. That's not a hypothetical future rule. That's the law right now. Colorado's AI Act covers high-risk AI systems used in consequential decisions. The enforcement was delayed till June the 30th, 2026, but companies with fewer than 50 employees get an exemption. However, only if they're not training AI on their own data. California AB 2013 is primarily aimed at AI developers, companies building models. If you're using off-the-shelf tools, this probably doesn't affect you directly. Texas has its own AI Governance Act with internet-based liability and a 60-day cure period, and New York's RAISE Act, signed at the end of 2025, takes effect January 2027. Mainly targeting large AI developers, but signaling the direction of travel. Layer 3, the UK. There is no standalone AI law in the UK as of early 2026. The government has deliberately chosen a sector-by-sector approach. But don't mistake no AI law for no obligations. UK GDPR already restricts automated decision-making that produces legal or significant effects on individuals. Data protection impact assessments are legally required before deploying AI that processes personal data in high-risk ways. The ICO fined Clearview AI £7.6 million for scraping facial images under existing GDPR powers. So the tools may be new, the principles regulators are applying are not. A dedicated UK AI bill is expected later in 2026. Now that you've already got the map, let me show you the one distinction that changes everything about how you think about your own exposure. Every AI regulation I've just described draws a fundamental distinction between two types of organization. The first type builds AI. They are called providers. The second type uses AI. They are called deployers, and the compliance burden on each is completely different. A provider is a company like OpenAI, Microsoft, Google, any organization that develops an AI system and puts it on the market. Providers have the heavy obligations: technical documentation, conformity assessments, regulatory registration. It is a serious compliance operation. A developer is a business that takes those tools and uses them. Now, that's most of us. If you're using ChatGPT, Microsoft Copilot, Salesforce, Einstein, or any of the off-the-shelf AI tools, you are a deployer and not a provider. And the compliance burden on deployers is substantially lighter. Think of it like restaurant equipment. If you run a restaurant and you buy commercial ovens, the manufacturer is responsible for safety certification. You're responsible for using it properly, training your staff and not ignoring a fault warning because you're busy. So, same principle. As a developer of high-risk AI systems, your obligations are meaningful but manageable. Use the system according to the provider's instructions. Ensure meaningful human oversight. Retain logs for a minimum of 6 months. Inform workers or affected individuals when AI influences decisions about them. Monitor performance over time. Those are real requirements, but they're not the same as building a conformity assessment framework from scratch. So here's where it gets important. 3 things can accidentally reclassify your business from developer to provider. First, white labeling, putting your company's name on an AI system as your own product. Second, substantial modification, significantly fine-tuning or retraining a model. Third, and this is the one that catches people out, changing the intended purpose. So if you take Microsoft Copilot, a general productivity assistant, and configure it to rank and screen job candidates, Copilot wasn't designed and marketed specifically as a recruitment screening tool. So by deploying it for that high-risk purpose, you may be changing its intended use in the eyes of the law. Now, that could reclassify you as the provider, responsible for conformity assessments and technical documentation that a 50-person company simply cannot produce. The practical implementation. If you need AI for a high-risk function, use a tool specifically built and marketed for that function by the vendor. That way, you remain a deployer. Now, regulatory enforcement is still early. Most large fines have targeted big companies for clear misconduct, not businesses making good faith compliance efforts, but the pattern of what regulators are looking for is already visible. In September 2024, the FTC launched Operation AI Comply, a coordinated enforcement sweep against 5 companies simultaneously. Do Not Pay, which marketed itself as an AI robot lawyer, was fined £193,000 for making exaggerated capability claims. Intellivision was sanctioned for claiming its facial recognition software was free from racial bias, and Evolve Technologies was penalised for telling schools its AI security scanners reliably detected weapons. The thread connecting all 5, companies making AI capability claims that they couldn't prove. Italy's Data Protection Authority fined OpenAI €15 million for processing personal data to train ChatGPT without adequate legal basis. Clearview AI has accumulated over €100 million in fines across multiple European countries for scraping facial images without consent. And in Germany, financial institutions were fined €492,000 and €300,000 for using automated decision-making in credit applications without adequate human oversight. Now, notice the pattern in the German cases. Those aren't about building AI, they are about deploying automated decision-making without the right oversight and transparency in place. That's the deployer's obligation territory. That's where SMBs sit. Right, the checklist. I've organised this by urgency. So Tier 1, do this month, no budget required. First, build your AI inventory. Survey every department, what AI tools are people actually using? Not just the ones your IT team approved. A quarter of organizations don't know what AI services are running in their environment. You cannot comply with regulations you don't know apply to you. So fix visibility first. Once you have the inventory, classify each tool against the EU AI Act's risk tiers. Recruitment screening, high risk. Customer chatbot, limited risk. Spam filter, minimal risk. This mapping costs nothing and tells you exactly where to focus. Second, draft an AI acceptable use policy. Define what tools employees may use, what data may be entered into them, what decisions require human review, and what is prohibited. This directly addresses the AI literacy obligation that's been enforceable since February 2025. Tier 2, this quarter. Third, assign someone accountable. Designate a specific person responsible for AI governance. They don't need to be technical, they need to know what AI your business uses, what the obligations are, and who to contact if a question arises. Only about a third of small companies have done this. Put someone's name on it. Fourth, conduct basic risk assessments. So for each AI tool, document what could go wrong, whether it could produce biased outcomes, what personal data it processes, and what happens if it fails. Write it down, date it. That document is evidence of due diligence. Fifth, review your vendor contracts. For any AI tool used in high-risk contexts, request the vendor's compliance documentation. Ask whether they've completed relevant conformity assessments, and if a vendor can't give you basic compliance documentation for a product deployed in a consequential context, that's worth noting. Sixth, implement human oversight for consequential decisions. So no AI system should make a final decision about hiring, firing, credit insurance, or any other consequential outcome without a trained human reviewing it and having actual authority to override. AI assists, humans decide. Tier 3, before August 2026. So if you operate in the EU or if you serve EU customers, establish 6-month log retention for high-risk AI systems. Conduct fundamental rights impact assessments before deployment and set up notification procedures for affected workers or customers, and confirm human oversight arrangements are in place. For any customer-facing chatbots or AI-generated content, implement disclosure. Users must be told they are interacting with AI. If you have operations in Colorado affecting residents through AI-assisted decisions, impact assessments, consumer notice procedures, human review mechanisms, and a public website statement on AI use, all before June the 30th, 2026. And regardless of where you operate, consider the NIST AI Risk Management Framework. It's free, it's government issued, and it's recognized as a safe harbor, both under the Colorado AI Act and the Texas law. It aligns well with the EU AI Act requirements, and it's free. The framework exists, so use it. 4 traps before I close. Trap 1. Using a general purpose AI tool for a high-risk decision because it's convenient. This could reclassify you as a provider. Use tools specifically designed and marketed for the context you're deploying them in. Trap 2. White labeling or rebranding an AI tool as your own product. This triggers full provider obligations. Unless you have the compliance infrastructure to back it up, avoid it. Trap 3. Assuming that because enforcement has been light, the risk is low. August 2026 is when the EU AI Act's full enforcement machinery activates. The window to do this sensibly before regulators are actively looking is now. And trap 4, treating AI compliance as an IT problem. It isn't. It's an operations problem. The questions regulators ask: do you know what AI you use? Do you have human oversight? Do you inform affected people? Those are questions for your COO and your ops team, not just your developers. Here's what I want you to take away from this. AI regulation is real, it's active, and it's expanding. But for most small and mid-market businesses, the compliance burden is manageable because you're a deployer and not a provider. The heavy lifting belongs to the AI companies building the technology. Your job is to know what you're using, document your decisions, and keep humans in the loop, and tell people when AI is involved. That's not a compliance program that requires a legal team. It's good operational hygiene that you can start on this week. The 6 items on that checklist: inventory, policy, oversight, risk assessment, vendor overview, the NIST framework, are the things that separate businesses who will navigate this confidently from those who will be scrambling when a regulator asks questions. You've now had the briefing most businesses haven't received yet, so what you do with it is up to you. If you want help thinking through what any of this means for your specific business, the AI inventory, the governance framework, vendor review, that's exactly the kind of work we do at AIAIO. There's a starting point at aiaio.me if you want to explore it. And if you found this useful, there's more on the channel about how AI automation actually works inside real businesses without the hype. I'll see you in the next one.